Right, well, good afternoon, everybody, and thank you very much for taking time out at, I'm sure, what must be a very busy time to join us in these unusual circumstances, although happily on, I think, the first sunny afternoon of the year. This is the first of what we hope will be a series of presentations to take place while we have the current very unusual circumstances in place. This one's given by the Commercial and Regulatory Department, a bit on that later, but our colleagues in Napton's Employment Department have already given a number of webinars and indeed are giving another one at 11 o'clock tomorrow. Should you like to join that, please just have a look on our website and the details are there. We will be looking at some other issues as well as time goes on. I think we were having intending to have a look at GDPR aspects, how to deal with GDPR in situation. Circumstances, and we're also planning to present generally on risk minimization in a crisis. Now, just before we start, just to say we will be taking, we can have questions during the slideshow. So if anything does come up that you'd like to ask about, please write that down. For technical reasons, I won't be able to address it as we're going on, but I'll be able to have a look at it at the end. And if we don't get to it, don't worry. We've got your details, and I'll be able to contact you later if you've got a specific query. Okay, just a quick introduction to those of you who don't know us. My name's Jon Esner. I head up Napton's Commercial and Regulatory Department. Before I joined Napton's, just a couple of years ago, I'd spent just shy of 20 years in industry with a number of large and generally well-known businesses. I'd spent some time at the Co-op, obviously very large, very well-known multi-sectoral business with a big retail focus. I'd spent some time with Arriva, the transport and travel provider, and my last 9 years in-house I spent as legal director of Wyndham, the very large travel group, one of the UK's biggest travel businesses, where I looked after the legal affairs of the likes of Ho Seasons, James Villas and RCI. So I did come across a fair amount over that spread of crises in my time. None, I have to say, quite on the level of this one. I do get very strong support in my role from my team colleagues, Rachel Atherton. Rachel's also spent quite some time in industry, in the travel industry as well. Rachel's a specialist in IT, as well as that, and also my colleague Claire Hines. Claire, in particular, specialises in retail and e-commerce and in online training. A very quick word about Napton's, because I think many of you will be very familiar with us. We are a leading regional provider of commercial legal services. What we aim to do is to provide really the full commercial package. We see ourselves as being a provider of a city service, but with the very strong regional and relationship focus that comes from our Northwest base. If you've got a question not related to this, and you're wondering whether we can help, the answer is almost certainly yes. So please do get in touch We've got all the contact details on, and we can discuss. Very quick snapshot again of the commercial regulatory team. We are proud to be the only dedicated commercial and regulatory team outside of the big cities in the northwest. We have particular strength in certain areas, including IT, e-commerce, retail, travel, manufacturing, transport and logistics, and training. But aside from those specific areas of expertise, again, we will provide right across advice, right across a multi-industry level. So if you do have a question and you would like to put it to us, please do. Okay, on to the current situation we're looking at. As I said at the head of the lecture, I think we're all in uncharted territory as a result of current events, and businesses are going to be faced with questions that they've not had to consider before. And the point of the aim of this specific webinar is to look at what happens to a business that's put in a situation because of current events where it can't do what it's agreed to do. Now, for obvious reasons, we can't cover all the bases. There are going to be a multitude of issues arising out there. But what I thought we'd like to do is to sort of explore the principles, explore the considerations through the focus of looking at three sort of specific examples. And those will throw up, I think, some of the issues that a lot of businesses are facing. So example one that we want to talk around is that of a supplier of goods, a wholesaler, a large business, who wants to cancel or delay a contract that it can't currently perform, perhaps because it can't source raw materials, maybe it's sourcing them from a Chinese manufacturer, or it could be, at the moment, it could be a manufacturer anywhere in the world, Italy, Spain, somewhere that's been particularly impacted by the crisis. The second example I wanted to look at was that of a perhaps a smaller business, a restaurant or other retail business, which has placed an order for maybe perishable goods, something that it no longer needs. It's placed the order, but it no longer needs those goods because it's been ordered by the government to close. We all know what's happening at the moment, and it wants to cancel that. Can it do so? And then thirdly, I was going to look at the specific example of a consumer-facing business. And in this case, we thought we'd look at a travel business faced with customers who want to cancel and suppliers who can't provide accommodation for it because they have been ordered to close. So that third business there, dealing with consumers and getting it really from both sides and looking what kind of solutions that business might have. So just to summarise those, scenario one, our wholesaler, they're there in the middle of the supply chain. So they've got a producer who's simply not delivering. They placed an order and the producer has contacted them to say, sorry, no can do. So they can't fulfill through no fault of their own. They can't deliver to their end customer, the retailer, who's expecting delivery. Scenario two, our small business, our restaurateur, they've placed an order in better times with their food wholesaler for food. The wholesaler, well, they want to deliver. They can still deliver. They've still got the meat in the back of the van that they want to bring. But of course, our restaurateur no longer has any need for that. It's not trading. So what can they do? And then the third scenario, as I mentioned, the travel provider who can't honour current bookings. So they've taken bookings maybe for cottages anywhere in the UK or indeed abroad. They can't honour those anymore because, of course, many hotels, villas, etc. have been ordered to close. Many people can't move unless it's for essential reasons. And they're also likely to have the additional problem of customers who perhaps have booked for summer holidays, who are looking at the current situation and thinking, oh, right, don't fancy paying for that. So they're looking to cancel. So again, we'll look at what the possibilities are for the travel provider. So where do you start in any of these situations? Well, any of these providers need to ask one question. And that question should be, do you have a written agreement? Hopefully, in most cases, you will have. We recognise, of course, in some cases there won't be, that there'll be a course of dealing. So we'll look at that, so what that situation is at the end. But the first question is, do you have a written agreement? If so, what does it say? Because the devil and the answer are likely to be in the details there. What we find, what you're likely to find is that your contract says quite a lot about what happens if you are in breach, because that's the unavoidable situation that a lot of these businesses are going to be. They're going to be sitting in a situation where they cannot perform. So we'll have all sorts of probably quite unpleasant clauses that you're going to be looking at, perhaps liquidated damages, which says, oh, if you don't deliver on time, then you'll have a specific sum accruing. We see these in particular in construction agreements and time-critical agreements where things are late as well in the logistics industry. Or there might be rights to terminate on the other side. So the person who's not breached might have the right to terminate and then sue for damages. Customers in the situation of our consumer business, our travel business, well, that's likely to be dealing on its standard terms, and those customers are likely to have specific cancellation rights. So we'll have a look at what those say. But that's all well and good. But how do we avoid being in breach, or how do we mitigate that breach? So let's have a look at what we're likely to be facing. So once you've got your contract out and you're thumbing through it, your contract or your head to terms or whatever we've got, what you're likely to be looking for is a clause that's generally known as the force majeure clause. It got this name because English lawyers, the English lawyers who first started drafting these clauses, they nicked it from French civil law, which had provided a sort of an escape clause, a matter of law, where one party was unable to perform because of what they called superior force. And this idea was adopted because the English law was felt to be inadequate. It was very strict, and we'll get on to that in the end. So what English lawyers did was they said, okay, we'd like a bit of that. We're going to put it down in our own agreements. It's not a clear term, force majeure. So sometimes you do see from time to time in contracts are terms in there that says this contract will not apply in the event of force majeure. Well, unfortunately, that doesn't help you because we're not in France, and the English courts are still quite sniffy about the term, and it's actually been ruled that using force majeure isn't clear enough, and it won't get you what you need. So you really need to look at your force majeure clause and see exactly what it says, because they're all different, and they will all provide for different things and different actions to occur. Typically, having said that, they follow a pattern. And the pattern is that they generally set out a list of events, almost inevitably bad and generally catastrophic events, and they say what will happen should these occur. And of course, as lawyers, we put these in, and we hope that, of course, they'll never need to be activated. But we need to look at the list and whether the specific event that we're needing to terminate for or to delay for is covered. And The good news is that if you've got even at least a half drafted clause, that it's likely to provide and cover for an epidemic of the kind we've got now. But that only gets us one step on the way. You need to look at it and see what the details are. Ask yourself, for example, does it benefit both parties or just one? In a nice, negotiated, fair agreement, hopefully it will benefit two. But, of course, many businesses are dealing on their own standard terms, and the standard terms generally just help the provider. So if you're the recipient of the standard terms, it's unlikely that the force majeure clause that you find will help you. And that's going to be, I think, a particular risk for the small business, the restaurateur that we were looking at. If he just picks out his supplier's terms, he's likely to find that you give a lot of rights to the supplier, but they probably don't allow him to terminate, especially when it just comes to him not being able or not wishing to pay his bill for his order anymore. And having said that as well, there are an awful lot of large businesses as well who, for reasons of practicality, often are trading on other party standard terms. So it's really important to get it out, see what it says. Having checked who it will apply to, then have a look at what you have to do, because very often the requirements of what you need to do to activate your force majeure clause are often quite specific and quite strict. For example, one I've just advised on said that the person looking to rely on force majeure had to send a notice within 3 days. And often this can be even stricter. So if you miss that 3-day limit, then you might find that you're not able to rely on your clause. And then it will set out what will happen. It may give you delay, it may allow you to terminate. We'll have a look at some typical examples now. So this is a good, fair, I think, pretty well-written clause that gives rights to both parties. It's the kind of clause that our wholesaler, hopefully, is looking at, is now thumbing through. Because they, hopefully, were in a position where they negotiated their agreements with their supplier, and they insisted on having something fair in place that went both ways. It's not necessarily just the large business, just the wholesaler who might have one. Our restaurateur, he may also have one of these. He may also have negotiated this for him or herself. But it's likely that the large business is likely to be seeing these kind of terms. So let's have a look at the detail. So if we look, starting from the top, there's a list of events set out, examples. They're said to include without limitation. So if your specific list doesn't appear here, it doesn't mean that it's automatically excluded. But we can see, yes, that the lawyers who drafted it were thinking of epidemics and pandemics. So your first box is ticked. Yes, you're covered. Okay, so what flows on from that? What kind of slack do you get cut if we're in an epidemic position? Well, we go down to the bottom, clause 20.2. If a party is prevented, hindered, or delayed in or from performing any of its obligations under this agreement by a force majeure event, they will not be in breach or otherwise liable for any failure or delay, and the time for performance will be extended accordingly. So we have a position there where our wholesaler, they've been affected by a force majeure event, which has caused error because their own supplier hasn't given them raw materials. So they can turn around to their retailer and say, look, yep, this applies. I know you're expecting us to deliver next Thursday, but I'm afraid we can't do so. So in principle, this is some considerable help for them. It then goes on to give a little more detail. So, for example, we're now in the realm of conditions. We see that the obligations of the other party, it's both ways, are also delayed and suspended. So the other party logically doesn't have to pay as well. They're not getting their delivery, so they don't have to. They can turn around and say, well, yeah, even though we can't sue you for non-delivery, you can't sue us then for non-payment. But we have, as I say, got some quite strict conditions that we've got to comply with. So if we look at clause 20.4a, the highlighted sections, our wholesaler has to tell the other party about the force majeure event, and they have to give quite a lot of detail. Although it's fair to say that this is not going to be coming as a surprise to their retailer, but they've got to do that on the date on which it started. So they've got to act very quickly, and because these clauses are likely to be construed quite strictly, you've got to be very careful to jump on this and give as much detail as you can if you're relying on a clause like this as soon as possible. If we look at B as well, we can see that this is really not a get-out-of-jail-free card either. You've got to use, as it says, all reasonable endeavours to mitigate. So if we've got a wholesaler who, they can't perform because their own supplier hasn't turned up the goods, well, I think that it would be reasonable for them to be going out looking for other suppliers, seeing what they can do. Obviously, if they're being held to ransom in terms of cost, that might be felt to be not reasonable, but they still have to make quite reasonable efforts to make sure that to try and fulfil their obligation. And then what happens at the end of this? Well, we're given a sort of a long stop to all this. So if it continues for more than 3 months, so if the parties are just left hanging for 3 months, unable to deliver, unable to pay, etc., the party not affected, so the retailer who's sitting there unable to get their delivery, they can then terminate by giving 6 weeks written notice. So, yes, very helpful, I think, to the wholesaler in this circumstance. Perhaps not so helpful to the person expecting a delivery, because those timescales in this clause are very long. So they've got 3 months to wait, and then another 6 months, another 6 weeks rather, before they can give notice. So, so the person sitting at the end of the supply chain, they can't really go and seek something else, unless, of course, they negotiate separately to bring this to an end, which is, I think, what's likely to happen in a lot of these circumstances. But they can't themselves terminate this and go and seek another supplier. Then, of course, they may not be able to. Okay, let's have a look at another example. Well, this is a real-life one that I pulled from a set of terms and conditions. Typically, I think this is the scenario that perhaps the small business person will be facing, the restaurateur who's placed that order. Although possibly the wholesaler too, because of course many large businesses are just going to be accepting standard terms. Everyone's contracting day to day quickly in practice. And the first thing we see about this one is it really isn't half as good as the first one we looked at. Ignore the fact that it refers here to a maintenance contractor. Of course, it could be any provider of goods or services. But it more or less does the same thing. It says that the supplier will be under no liability, and it sets out a list of events. Typically, these always start with war, but war, riots, government requisitions, suspension or loss of means of transport, and it goes on, failure for any third party to supply, so that might be very helpful, or anything directly or indirectly interfering with raw materials and manufacturing outside the control of the maintenance contractor. So that's all it says. So it puts it doesn't give a period of delay. It doesn't give us a solution in terms of an endpoint termination, but it basically says that the supplier ain't going to be liable. And a clause like this will almost certainly work between businesses. Businesses are deemed to have taken notice of these and to have agreed them. So it's unlikely to be ruled unreasonable. So for our restaurateur who's sitting on the end of this, and they're looking at their standard terms and thinking, can I terminate this order that I no longer need? I think they're likely to be struggling. I don't think this is going to help them. Of course, their own provider is going to be sitting quite comfortably at this part of the supply chain, at least. I'm assuming they'll have issues elsewhere, but they can say, they're likely to be able to say, well, no, sorry, you can't cancel, even if we're late. This doesn't give you any right specifically to terminate your order. Okay, and then if we move on to the travel provider, we can see that I took this clause is similar to a lot of ones I see online for large travel suppliers. I just state at the beginning of this, we're not looking at package travel regulations. We're leaving that aside. That's a whole different and more complicated level of law, which is causing problems at the moment, but we're not going to look at that. But we can see that our travel provider here, dealing with consumers, they put in a clause which is actually quite similar to the B2B, business-to-business agreements that we've looked at up to now. And it has a lot of the similar elements that we've seen before. So we've got the travel suppliers saying they won't be legally responsible, so the language is obviously a bit more consumer friendly, or have any liability to you if we're prevented or delayed from doing what they're supposed to do by anything out beyond their control. And again, we have the typical lists, natural disasters, and we get down, if we can see, keeping to any law or governmental order. Well, that's likely to apply if premises that they're booking out have been shut by order. And we can see advice from foreign office or other health or governmental local authority, and even more specifically, going over the page here, significant risk to human health. So again, this was covered. So the travel supplier is probably thinking, yes, great. I'm out. I'm in quite a good position here. However, as with all providers of services to consumers, there is a big but, which is that this is unlikely to provide a total solution to a supplier who, of course, has been paid to provide a service, has taken consumers' money, or at least a significant amount of consumers, maybe a deposit, and then is looking not to perform, because the courts will quite rightly say, well, hold on a minute, you can't just bank the money, put it in your pocket and not provide the holiday. So even though this specific clause appears to be quite helpful, I don't think it's likely to provide a full solution if you are looking to escape from a refund in these situations. I think it's helpful, perhaps, in setting out, if you might want to refer to it as being there, but ultimately, I think trying to rely on this would be quite difficult. It's also very likely that, as we've mentioned, that the poor old travel provider at the moment is going to be getting it from all sides, because they're in a position, of course, where they can't provide a holiday because their own suppliers simply can't legally function and people can't legally move. But they're also likely to be in a position where you're going to have travellers who are due to travel, perhaps maybe June, July, who are getting cold feet or who are looking at their own jobs and thinking that committing to £1,000, £2,000 for a holiday is unwise, so they might be looking to terminate. Well, in a lot of consumer contracts, specifically travel contracts, we see that there are sliding scales giving us rights to termination. So, in principle, those are likely to apply. So the consumer is likely to be able to rely on these clauses. So, of course, if they're cancelling for summer, then the consumer is likely, I think, to lose their deposit or whatever the amount is that we can see here, up to 50%, sliding up to 85%. If we had a situation, you can see where the consumer wants to cancel immediately, in principle, again, the supplier, the travel company, gets to keep 85% of the money. I think that's an unlikely scenario at the moment, that the customer's going to be cancelling now, because for obvious reasons it's more likely to be the supplier. But again, if that were the situation, if you were in a situation where you're saying, well, hold on, yes, we actually feel we can still provide, so you've got a traveller who's looking to cancel, again, I think you would come across a court taking a rather dim view if you sought to try and rely on the fact that a traveller was cancelling because they simply couldn't travel because of the law. They'd been prevented from doing so, and you were looking to try and keep 85% of the money. I think the likelihood is that real life here would intervene, that we'd be looking at the law, but we'd also be looking at reputation, we'd be looking at goodwill, we'd be looking at keeping businesses going, so that businesses will be likely to be making offers very much based on what was commercially viable to them. So they might be writing to customers saying, look, we're looking to transfer, or if you don't want to transfer to another date, we maybe cancel and make a charge, a minor charge to cover our expenses. Indeed, there might also be clauses in the contract dealing with cancellation by the supplier, which sets these things out as well. One thing I'm afraid that is likely to come out of this is there's likely to be, of course, a lot of claims around these kind of clauses, both between businesses and between businesses and consumers. So I think that unfortunately, we're going to see this, though it may hopefully be over in a few months. I think we're going to see the results of this drag on in the courts for quite some time. For each of those examples above, to sum up, what do you need to do? What are the key issues? Have a look to see if you've got a contract, see what's in it, see whether the events you're looking at are covered, see who is covered. Is it both parties, or is it just one of the parties? What action has to be taken? Do you have to give notice? Do you have to give details? Look quickly, do it quickly. What happens? Do you get delay? Do you get all your right? Do you find yourself in a position where you have no liability at all? Does it lead to a termination of the agreement? Does it give rights to terminate after a certain period? So have a look and see if that's what you want to happen. Don't forget the background law, because especially with consumers, no matter what you put in your contract, there's going to be a level of law sitting behind that. So even though in principle your force majeure clause may be very, very helpful, you may find that the courts take a dim view of it, particularly when they're faced with a large business against a consumer. And of course have an eye to the practical reality, and as I'm sure is going to be happening and will be the immediate priority, speak to the other side and see exactly what can be done, and think about mitigation and offers. Okay, so that's a look at what might be the position if you do have a written contract in place. What happens if you either, and there are two situations here, you either do have a written contract, but it doesn't cover this particular set of circumstances, which it might. You might not have a force majeure clause, or you might even have a force majeure clause which is drafted in such a way that it doesn't talk about epidemics, although I think pretty much all of them will be widely drafted enough to cover this. Or you have nothing in place at all. You're dealing on a course of dealings, so there's nothing in place. So what happens then? Well, then we fall back to the English common law and statute. And we look at a position here where there is potentially an escape. There is potentially some help for the party who can't perform, but in most cases it may not be good enough. So, for example, frustration, which is what we're looking at here, the doctrine of frustration, has a very strict test. And it does allow for a contract to terminate when very unusual and unexpected events happen, but it has to comply strictly with these rules. And if we have a look, it says the event has to take place after the contract is formed, and that, in most cases that's going to be the case. It's got to be fundamental and beyond the contemplation of the parties at the contract formation. And again, I think we could say it's likely that the current situation will apply. It's got to be neither party's fault. Yes. And it's got to render further performance impossible, illegal, or radically different. And I think this is where a lot of the examples, or certainly the wholesaler and the restaurateur in particular, would struggle, because we've got a restaurateur, they've placed the order, their wholesaler has let them down, they placed the order, their wholesaler, their person delivering to them hasn't let them down, they're delivering, they still want to go ahead with the order. How is their payment impossible, illegal, or radically different? It isn't. So this is where I think we look at the problems with the fallback of the English law, that even though something really bizarre and unfortunate has come out of left field, it's not likely to help our poor restaurateur, especially when they're faced with a supplier who's saying, yeah, I've still got your goods, I still want to deliver, I still want you to pay. So I don't think, unfortunately, this is going to help them. Tip also with the wholesaler. Their own supplier has let them down. They haven't got raw materials, but their retailer, to whom they're supposed to be delivering their goods, is saying, well, come on, where is it? And they're saying, well, we can't get hold of it. But unfortunately, it doesn't mean their performance is impossible, illegal, or radically different, because it simply means that they haven't sourced goods. So I think, unfortunately, this may not necessarily help them. Could it help the travel provider? I think it could well, because the travel provider, if they didn't have terms, they would be able to say, yes, we can't perform because it's actually illegal for us to do what we're doing. So I think it could well help them, although it's be quite unusual for a travel supplier in those circumstances not to have written terms and to have provided for what will happen. So I think that's one of the dangers, I think, of not having a written agreement in place in these circumstances. But just have a look at, just to run through what actually happens if we're looking at the background law, the law of frustration. The parties, again, as we often saw with the force majeure clause, they need to act immediately. Again, you can't delay. You've got to write to your other party and say, right, yeah, we consider, we've had, because of what's happening, we think that our agreement is at an end. And it means that if you paid money before the end of the contract immediately comes to an end. It doesn't allow for any delay of payment or anything like that. But if you paid before the end, then you can, for something you're not then going to get, you are entitled to have those monies back. So, for example, in the travel supplier context, the consumer pays for a holiday. The holiday can't be performed. The consumer is entitled then to get their money back. But, and this is quite helpful of the law, it does say that the supplier is entitled, if they've incurred expenses, then they are entitled to take off those reasonable expenses before returning money. And the courts have actually applied this law quite helpfully when these kind of situations have arisen. They've looked at the individual circumstances, taken account of who's paid what, and tried to reach a reasonably fair conclusion. But as I've said, the big problem with the law of frustration is that it's very, very strict, and it often doesn't help to give us things like delay or provide or help parties who are indirectly affected by force majeure. Okay, so to summarise all of that, key point number one, check your contract in the event that you've got one. Follow any force majeure contract provisions that you've got that are likely to help you. If there are other provisions in there dealing with contract cancellations that we've looked at, there might be other liquidated damages clauses, etc. Have a look at those, see what's likely to apply. If there's nothing in the contract which appears to help you, it may be that the background law will apply. And that the background law might help you and might apply and mitigate some of the consequences as well. I probably don't need to remind you, as mentioned before, real life is going to intervene here. You're likely to be negotiating, talking to your suppliers, making offers to consumers. All that is going to be going on as well, but it's going to be underwritten by your view of what your legal position is. And of course, please take advice. We're here to help with this and many other issues. If you'd like to contact me or message me, please do so, me or any of the other members of the team. This webinar, if you'd like to listen to it again, and with the slides, will be on LinkedIn. We'll post it up on LinkedIn and be on our website. So I'll just have a quick look, see if any questions have been raised. No, we don't seem to have any questions. So really that just goes to me to thank you for attending. If you would like, as I say, to raise any specific issues, please do get in touch, and I look forward to your joining us again, hopefully shortly, for our next webinar. Thank you.